case briefs, and so much more. LSData's got what you're looking for.
In 1978, the Kansas Supreme Court heard the case of Gerchberg ex al. Gerchberg v. Loney, which centered around the level of care property owners owe to visitors depending on their classification. The case involved a 5-year-old boy named Rolf Gerchberg, who suffered serious burns while playing on his neighbor's property, owned by Mr. and Mrs. Roy Loney. The district court initially ruled in favor of the defendants, but the Court of Appeals reversed the judgment and remanded the case based on the theory of attractive nuisance. The plaintiff argued for a single standard of reasonable care owed to all visitors, but the Court of Appeals disagreed. Instead, the case focused on determining if the evidence supported the theory of attractive nuisance. The majority of the court approved the Court of Appeals' opinion, noting that the plaintiff's burns resulted from an unattended smoldering fire in a barrel left by the defendants. A 10-year-old neighbor had previously been directed to burn papers and started the fire, leading to Rolf's injuries when he put papers into the barrel. The court decided that the plaintiff's case proceeded on the theory of attractive nuisance, maintaining the distinctions between duties owed to invitees, licensees, and trespassers. The court rejected the plaintiff's argument for changing traditional classifications and applying the dangerous instrumentality theory, finding no independent duty owed by Mrs. Loney. The jury was then instructed on the law pertaining to attractive nuisance.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.